All right, here we are. Our Zoom meeting, and it's 2:31 and 2:32 actually, and we're waiting for them to get started. They should get started here shortly. We are hearing case number 201200335, and it is the state of Texas versus Timothy Emmett Damron. What we're hearing today is a motion to dismiss with prejudice and a motion to strike the state's affidavit for good cause. So, we'll wait for them to join us. It's 33 after, just for the record. Hello, Judge. Oh, there we go. Hello, Judge.
Hi, Mr. Damron. How are you?
I'm pretty okay. Thank you for asking.
All right. Let me get your follow-up in just a minute. Let me just have a moment. I'm getting a docket sheet written from earlier.
Okay.
All right. What motions are you asking to be heard, Mr. Damron?
I have a well, the first one that that I filed was the motion to dismiss prosecution with prejudice, and that one was filed or postmarked because I have to mail stuff from here, but it was postmarked January the 26th. And then also in response to the state's affidavit for good cause that was filed pretty quick, like an hour or two before the last, not the last hearing, but the hearing before last, we reset so that I would have an opportunity to also answer that. So in respects with that, on the 18th of March, I filed a motion to strike the state's affidavit for good cause. And the reason I didn't, I could go, if the court would allow, I could go in and just start, if that's okay.
Go ahead. Tell me what you want to tell me.
I appreciate it, ma'am. Thank you. Your Honor, the state's affidavit for good cause is a bit conflicting. It's conflicting with the complaint that's also here, and here's why. When you go to State's Exhibit 1, which is Ms. Sessions' exhibit, which is also my exhibit 2, which is the arrest affidavit, within the first 3 lines, the arresting officer, Jerry Kalin, states under oath that he was summoned to the lobby of the Houston County Sheriff's Office. Okay, and of course, where I was there to retrieve personal property that was seized really unlawfully. There was no reason for them to seize it, and they took it anyway. So I was there just to get my property back. And what happens, what has evolved on December 17th was another affidavit that was generated by Jerry Kalin as well, that states that this arrest and the offense occurred on or within 1,000 feet of a playground, to wit Crockett City Park in Crockett, Texas. And I think that these are conflicting because he states first I'm within the lobby, and then I'm within the playground. And you certainly can't be in 2 places at one time.
How far did he say you're from the playground?
I'm sorry?
How far does he say you're within the distance of the playground?
1,000 feet. And if you Google map the location from front door of the sheriff's office to the park, it's 1,534 feet. So, but like I said, I'm inside the sheriff's office, Your Honor. So if I'm inside the sheriff's office, I can't be inside anything else or within anything else other than the sheriff's office. Like, literally speaking, this doesn't, it conflicts with itself because it doesn't make any sense. Mr.
I'm
Kate?
going to object to relevance. His motion is to dismiss based on 2 sections of the Code of Criminal Procedure. And not...
Your Honor, I'd like to...
Facts and issues that those are disputed, that would be something to be decided if there's a trial.
But Your Honor, I respectfully, I object to Ms. Sessions. If Ms. Sessions had input on any of these things, she certainly had time to file a response with the court, and she has not. And nor sandbagging a response today really doesn't give me a fair shake at anything that's happened today. I'm certainly giving the court plenty of notice on this. And one of the reasons that I do want to strike this affidavit for good cause is because the affidavit is conflicting. Mr. Kalin makes an affidavit, an arrest affidavit in 2019, in October of 2019, and then recites that and states on December the 14th, on the same event, stating that I'm in another place. He also states in his arrest affidavit that, under oath, that he recognizes that I had hemp, I had something that smelled like marijuana, and something that tested for synthetic cannabinoids. He also states that as well. And these things can't happen. You can't have a hemp product test for cannabinoids. And I think that Ms. Sessions kind of explained that when she divulged all the testing information that was done, which, by the way, hasn't been conclusive to say anything else other than it is hemp. And it was purchased legally.
Can I stop you for a minute, Mr. Damron?
Yes, ma'am.
You're defending the case, and you're not on trial today. The case is not being tried today. While these might be legitimate defenses to the case if it was on trial today, what you filed is a pretrial motion.
Correct. Correct.
presenting to me is argument for why you should be found not guilty, and in a case, but we're not on trial today.
I understand, Your Honor. If you'll just bear with me, I'll get to it.
What is your specific motion? What rules under the rules of criminal procedure are you trying to move us under to get before the court today?
Okay, I'm sorry. To dismiss or to strike? Which one?
Well, you have a motion to dismiss prosecution with prejudice, and then you're asking to strike her affidavit, right?
Correct. And I'm asking to strike the affidavit.
Affidavit is in response to your motion to dismiss prosecution for prejudice, right?
It's not titled that way, and I didn't receive it that way. No, because it's not titled that way. It just says a motion for just cause. It doesn't give an answer. It doesn't give a rebuttal to any of the points of law that have been brought up. So I could bring them up again, Your Honor, but just the fact that Ms. Sessions has not addressed any of these points, none of them. And furthermore, under Criminal Procedure 2806, 2807, it states very clearly that says when, and I'll just quote from it, it provides that if an exception to an indictment or information is taken and sustained upon the ground there is no offense against the law charged within, the defendant shall be discharged unless the affidavit being filed accusing him of a commission of a penal offense. And so, because, Your Honor, the 180 days ran out a long time ago on this, and
You have 2 years to file a case.
correct, but I was arrested and charged with a felony. We're converting this for just mere convenience.
You're not charged with a felony in my court.
I understand that.
You're a felony, Mr. Damron. I would have no jurisdiction over a felony. That would be district court that you would be in.
Correct, but State's Exhibit 1 that Ms. Sessions filed into the court case brings in this affidavit, the arrest affidavit, which concludes that I was arrested under a felony, and then we're just flipping it to another court for a matter of convenience. And, I understand that we're trying to save a bond maybe here, and I understand some of the legitimates of this, and I get it, but,
Save a bond? What do you mean? I'm not getting
is there an appearance bond for me today, Your Honor? Has there been an appearance bond filed for me today to appear?
You filed a bond when you got out of jail, and that's your bond that you're going to appear anytime the court sets a hearing.
But that bond that I was set for, I was charged with a felony. And Your Honor, just to further that too, the court accepted a writ of habeas corpus, and I asked for a speedy trial regarding this arrest. Okay, and I know that it was this arrest, but this arrest is connected, and this affidavit states that I was charged with a felony. So I know that it wasn't in your courtroom, Your Honor, but Ms. Sessions has introduced State's Exhibit 1, which concludes that I was charged with a felony. And I filed a writ of habeas corpus. It was signed off. It was accepted by the clerk. I have my stuff right here. And this was accepted it was mailed on April the 21st, 2020. No response was given. I asked for a speedy trial. And under this motion to dismiss, one of the articles that I bring up in here is very specific. Under 3201, it says, when a defendant has been detained in custody or held in bond for his appearance to answer any criminal accusation before the district court, I know this is before district court, the prosecution, unless otherwise ordered by the court for good cause shown, supported by the affidavit, shall be dismissed and the bail shall be discharged if an indictment or information be not presented, against such defendant on or before the date of court which he is held, or 180 days after the confinement. And more than 180 days is
confinement. Mr. Damron, that rule is saying if you were still in confinement on those 180 days.
Actually, Judge, it further does.
May I respond to his motion?
I would object to that response because, again, I think that we've had time to do that, Your Honor. And Your Honor, I'm going to further read the rule.
I've given you a long time to make an argument to me today, okay? We've probably been in here 15 minutes already. And Can I hear Ms. Sessions' response to your motion?
Can I finish?
I'd like to make argument. Okay, but you keep making circles, so tell me what your argument is. I'm not here to hear the felony. I'm not here to hear your writ, because neither one of those things are before me, and neither one of them are applicable to this case.
Well,
Okay?
Your Honor,
So I'm not making any decisions on your writ, application for a writ, or to be released under any felony, because I'm not here on that.
you're right,
Okay?
and
I'm not going on any of that.
you're right, Your Honor, and I'm in agreement with you on that as well. That obviously different courts have different places for different things, and I understand that. But in this particular case, Ms. Sessions has introduced evidence into this court that shows that I was originally arrested as a felony, and this is why I made an appearance. And under Article 27.05, Paragraph 4, Paragraph 4 says that it is double jeopardy if you have something that is not prosecutable. And because the felony was not prosecutable.
Prosecuted of the felony, you've not been prosecuted for a felony. You have not been convicted of a felony. Double jeopardy applies if you're being convicted of an offense that you've already been convicted of. You don't have double jeopardy.
Your Honor.
You don't have double jeopardy. You don't have a habeas corpus from a felony. You don't have request for relief. So I'm still trying to figure out what you do have and what you are moving on. What we have in this case is an information that's been filed alleging that you had possession of a marijuana, and they've alleged it in a drug-free zone on October 16, 2019. You may be completely innocent of that case, and you're presumed innocent at this time unless the state proves that case beyond a reasonable doubt, and you have the right to have a jury trial. Those are your rights that you have in a criminal case. And it sounds like you would have a good defense. You've made some good arguments for defense on the case, okay? Whether or not that proves to be true or not, though, I haven't heard the state's position. But I'm not going to hear the state's position on your underlying case today, because that's not what I'm here for.
You're right, Your Honor, and that's not what I'm trying to do.
And so what I want to know is on the possession of marijuana case, are you going to go forward and waive your right to counsel and represent yourself on the case? Or are you going to have an attorney represent you on the possession of marijuana in the drug-free case?
Well, Your Honor, I didn't have any marijuana, and the affidavit doesn't conclude that I did.
And you may not have any marijuana, and that obviously would be a defense to any charge of having marijuana in a drug-free zone, okay?
But
That's what trials are for, and you're trying to take care of this in a pretrial fashion, and I'm not aware of any right you have to take care of this in a pretrial fashion on this misdemeanor.
well, Your Honor, I think that I can. I think actually, kind of anticipated some of this.
Are you an attorney?
No, ma'am. Do I need to be? Is that a requirement?
It's not a requirement. Anybody has the right to represent themselves. But sometimes whenever you're not an attorney, you may be reading something that you interpret one way that maybe the law doesn't provide it that way. That's all I'm saying, Mr. Damron, okay?
I certainly appreciate that,
I
ma'am.
mean, I'm always open to novel arguments. I think that's fine. Attorneys make novel arguments. If you have a novel argument, I'm willing to listen to it. But all you've offered so far is that you're not guilty of this offense of possession of marijuana. That's all I've heard.
That's not true.
Not guilty would be original arraignment.
Your Honor.
Not guilty at arraignment.
Your Honor.
And then we would move on to pretrial, and then we would set the case for a trial and give you a jury trial if you want, or a bench trial, whichever you want. And we would hear the case, okay?
Yeah, well, here's the problem, Your Honor. The problem is that the state's affidavit for good cause is conflicting, because the state's affidavit that filed with this court states that I'm within 100 feet of Crockett Park. And if you look at State's Exhibit 1, the third line down, the actual arrest affidavit...
Mr. Damron, that would be a defense, okay? That would be a defense. That would be a defense. You would have a defense to being in a public park if you're not in a public park. How can they convict you of something if you're not there? Okay?
Well, that's what I'm trying to figure out. And
that's a defense to the case. So when we have the case heard, that would be a defense you could offer. You could go out and you take pictures, you could show the court, or
But, Your Honor,
whoever's here in the case and say, look, I was over here. This guy says I'm over here. In this statement, he says I'm over here. How can I be there if I'm here? Okay?
Well, and Your Honor, that I think that falls with probable cause, Your Honor, and I think it's a worthy argument for today because there was no probable cause to detain me on 10/16/2019 at all. There was no probable cause to arrest me. There was no probable cause to search me. There was no probable cause for me to be assaulted by this man in your jail because I had a lapel camera on my person. And that's what this all boils down to. And if we really want to get down to it, we had a simulating of legal process that was also filed as a misdemeanor, but hasn't appeared yet. And I also posted a $5,000 bond on that, and that had to do with Miss Womack's relative. And I think that there's some conflicts of interest here, Your Honor. Oh, yes. Simulating legal process. I was charged with that too. And I had to put, and that was a misdemeanor charge. And I posted a $5,000 bond for that. So, Your Honor, between this and this other case, I have posted over $15,000 worth of bonds that the felony arrest cannot be heard. And so what we've done is we've taken a 2-page arrest affidavit, shrunk it down to one big, long, run-on sentence, and said I'm somewhere that the arrest affidavit clearly says I'm not. And I don't think I think it comes down to probable cause, Your Honor. And I think it comes down to rights of due process.
All right,
And
let Ms. Session respond, okay?
Judge, the state is requesting that the court dismiss the motion to dismiss this case under the Code of Criminal Procedure. The cases that Mr.
Which one?
Damron have cited to, those cases apply to situations where an indictment or information had not been filed yet. Once the case is indicted or there's an information filed and that issue becomes moot, this case is moot because he did not file his motion and there has not been a ruling prior to the state filing its charging instrument, which is the information in this case. Secondly, we would ask the court to deny his motion to dismiss for good cause being shown as provided in the state's affidavit for good cause. The Exhibit 1 is to show the date of the offense and the date of the arrest. The following exhibits show his release, and it shows what has kind of taken place throughout the case that may have led to a delay, which had to do with the drug testing of the case, the Commissioner's Court approving a lab other than DPS.
I want to object to that. Can you show?
To send the drugs to have the drugs tested because the DPS lab does not test plant matter anymore. So we believe that there has been good cause as to why, if there has been a delay, then that would be the reason for the delay. For the third reason, the state would ask the court to deny the motion to dismiss is because the statute of limitations is 2 years in a misdemeanor case, and this case has been filed within the statute of limitations. So we would ask the court to deny his motion to dismiss on those reasons, because it's now moot, because there's been good cause shown, and because the case was filed within the statute of limitations.
May I rebut to that, Your Honor?
Hold on just a minute. I may have some questions. I'm going to put everybody on mute a moment, okay? Okay. Okay. Mr. Damron, your motions were both motions, and the motion to strike the state's response, or the state motion to strike the state's, state's affidavit. First of all, your motion to dismiss, that was filed after the information in this case was filed. Is that correct?
No, ma'am. The motion to dismiss was filed. Oh, yes, it was filed. It was filed after I was notified through the bondsman that I had a court date. I wasn't notified any other way. So on January the 26th,
was filed on December 18th. So your motion to dismiss was filed after that, right?
Yes, clearly, yes, ma'am.
Okay. What I'm seeing from what you've argued is that that motion to dismiss might have been timely to challenge whether or not the state had probable cause before the state filed the information. An information is like an indictment, but it's for a misdemeanor case. In an information in a misdemeanor case, in an indictment, you have a jury, a grand jury, that decides whether there's probable cause to go forward.
Yes,
okay?
ma'am.
But in a misdemeanor case, that same probable cause decision for filing an information is made by the prosecutor, the county attorney, because that's how we're set up on misdemeanors, okay?
Yes, ma'am.
So it's based on Ms. Sessions' finding that there was probable cause. She filed the information. Okay?
I was not, but I wasn't privy to that filing. She didn't give me any copies of it. It was done ex parte.
Sir, the information is what opens up your case. You don't have a case until the information is filed, okay? There's not a case against you. There's a charge, there's a release on bond, but there's not a case filed until the information is filed. So, no, you're not given a copy of that until after you are charged with the case, and then you're provided a copy of the information if you would like one. We usually mail one out, and we've been mailing them out since COVID. But if your address was different from the address on the bond, then we had no way of knowing where to send that. So that's why you got notice from your bondsman instead of your notice from the court.
But I think it goes back to what you were saying earlier when you were saying that you can't commingle the two. So if you're saying that we can't commingle the felony charge into the misdemeanor jurisdiction, but yet in fact we actually are, because I was bonded out on a felony arrest on a felony charge, and that very same felony affidavit is also being introduced into your court, and I'm confused, so maybe you could help me understand how.
I'm confused on that too, because that's not a normal part of the process. Normally, all I have is the information in the complaint,
right,
and then we go forward. But I think because you filed the motion to dismiss, Ms. Sessions did file the statement regarding probable cause, affidavit for good cause, in response to that.
But,
okay.
But Your Honor, like I said before, and if I could just get clarification, earlier in this court hearing, and throughout the last few months since February, this has been going on. I say, hey, I was arrested under this felony charge, and you're telling me, hey, this stuff can't be commingled in my courtroom because that's separate, and that's over here, and this is over here. But yet, this arrest affidavit that I was arrested on has been introduced in this court, and for some reason or another, it's okay. But if I try to contest it, then we have a jurisdictional issue. So
okay,
I'm just confused.
Let me stop you and ask Ms. Sessions a question. So, Ms. Sessions, what is the purpose of the state's affidavit for good cause that you filed?
Judge, based
documents attached to it.
as referenced in the code for good cause shown, well, that's the state's good cause. There are court cases that have been on the appellate level that I read that said the state would file affidavits of good cause and decision could be made just based on that affidavit. So that's why I filed the affidavit of good cause as another reason for dismissal. It's not required because it's moot, because cases say that once the information is filed, he has given up his claim. Once the information is filed, the claim under 3201 or 27, whichever one he's referring to, or both, is moot.
What law says
If there's
that?
not a ruling that is made by the court before that is filed,
Okay.
before that information is filed or the indictment, it's moot.
And I'm writing
So
that down.
The affidavit was just as an alternative into denying the motion to dismiss.
But
That's why I filed that.
Your Honor, for
Mr. Damron, I'm kind of stuck way back there at the very first step,
I
which
understand.
is that your motion wasn't filed before the information was filed. I'm not sure that I understand the state's affidavit for good cause. I'm not sure I understand that. And, but I think I could even grant your motion to strike that, and I don't think it affects whether or not your motion was moot or not. That it wasn't, if your motion was filed before the information was filed, then we might have a basis to have the case dismissed.
And under what rules? What rule?
My understanding, but basically it says I read that before the information or indictment is filed, I read that in what you provided, actually, is where I just read that. In your citation to the rule that you were referring to, it said that you could do that before the information.
But there's no way I could have done that, ma'am. There's no way, because you just said earlier that that's done without me knowing. So there's no way I could have filed a motion to dismiss before that was filed.
You could have filed that at any point in time. It wouldn't have been in this court necessarily. It would have been before the JP, if that's who found probable cause in the case initially.
Well, but that's my point, Your Honor, and that's why I'm asking to strike the motion strike the affidavit for good cause for a couple of reasons. Number one, my name is nowhere in that commissioner's court brief that you keep bringing up, Ms. Sessions. My name's nowhere in there. I haven't seen it.
It's not supposed to be. What's in there, because Commissioner's Court doesn't have anything to do with you. Commissioner's Court has to give me permission to spend the county's money to have evidence drug tested, which is what I had to do in your case.
Right, but there's no documentation of that in that report. So what did you submit the report for?
You have the affidavit.
Ma'am, you know what? The affidavit is perjurous, ma'am.
It shows the date that it went to Commissioner's Court.
Well, here's the problem.
That it went to Commissioner's Court.
Here's the problem. Your Exhibit 1 conflicts with your affidavit.
Everybody, I have a court reporter here.
Thank you.
Court reporter can make a record, but the court reporter can only make a record of one person talking at a time. Ms. Session and Mr. Damron, y'all were talking at the same time. So we got to take turns. We can't talk at the same time. So
I apologize, Your Honor.
Somebody wait till they're finished and then respond. Okay? My ears don't work that well either to hear two people at the same time. Even if the court reporter could take it down, even if she was the whiz that could take two people down at the same time, I can't hear two people at the same time. Okay?
Well, Your Honor.
So my understanding is you are objecting to the Commissioner's Court reference that she made in the state's affidavit for good cause.
It's hearsay.
I don't think I'm even going to go as far as looking at the state affidavit for good cause, because your motion was not filed before the information was filed.
There's no way I could have filed it, though, ma'am. How could I have filed that?
If that's wrong, then maybe you need to appeal me, and maybe you need to take it to another court to say why I was wrong in that decision. But that's what I see the process being, okay? So I wouldn't even listen to the state's affidavit for good cause, and not even your motion to strike the good cause. I'm just looking at your initial motion and that it needed to be filed before the case was indicted or the information was filed.
What rule was that? What rule is that under, Your Honor, so I could look that up?
Session, can you provide that to me again? I know he provided it to me because that's where I saw it just now.
I wasn't privy to that conversation, so you guys had ex-parte conversation about this rule?
No, we did not.
It sure looks like it.
This session, I want both of y'all to be quiet because you're both interrupting me. Mr. Damron, I have had no ex parte communication with anybody on this matter. If you're going to make that allegation, you make it in writing and you put it in writing to me, and I'll take it to another judge, and that judge can decide that issue.
Yes,
okay?
ma'am. Yes,
I take
ma'am.
that issue very seriously, and I give people fair hearings in this court. Do you understand that? And I'm trying to give you the fairest hearing I can today. Understand? And you're rambling on and you're interrupting, and I'm not going to have that. You understand that?
I hear what you're saying, Your Honor, and I apologize. I'm just saying that what you said was you recalled a conversation that you had with Ms. Sessions regarding this rule when I asked about the rule, and I just asked a question.
Sir. No, sir. What I said is I recall that rule from reading it just now in your motion to dismiss that you wrote and you provided to the court.
And I just asked what rule it was, Your Honor. And I just asked what rule it was, Your
And
Honor.
the court reporter can read that back to you if you want. But I didn't say anything about any conversation with Ms. Sessions. I'm referring to your motion and the rule that you wrote in your motion that says that it needed to be done before the information or indictment was filed. I'm dismissing your motion to dismiss, and we're going to proceed with the case. I will set it for pretrial arraignment. And are you going to represent yourself for purposes of arraignment?
Yes.
You want to go forward with arraignment today?
No. I need time to prepare for the arraignment.
Okay, arraignment is only to read the information and hear your initial plea on the case.
Well, I've already done that. I've already done it, and I'm requesting a hearing. I'm requesting a hearing under the right here under Article 3201 of the Texas Criminal Code of Procedure. I'm sorry. It's under 2705, and I did enter a special plea of double jeopardy, which means that which from what I understand, Your Honor, we have to go to a hearing, and then we have to determine if these matters have been heard. And I realize, Your Honor, that you have stated earlier that you stated earlier that is for cases that have indictments. And if I could just remind the court that Article 2705, paragraph 4 states and includes offenses that are not prosecutable. And this felony offense this felony arrest was not prosecutable. And because it was not prosecutable, Your Honor, I have entered in a plea of double jeopardy, and we could set that for hearing, and that's why I did it. So I'm just asking for a hearing on that.
Mr. Damron, you can either hire an attorney or you can sign a waiver and represent yourself without an attorney. That's all I'm asking you today. Whether or not you want to represent yourself or hire an attorney or ask for a court-appointed attorney. That's all the question I'm asking you now.
Well, I'm going to represent myself for right now, Your Honor.
Then I need you to sign a waiver of right to counsel.
But if I do that, then the court has the right to appoint me counsel, and then I'm quiet after that, and I can't say anything.
No, I'm not going to appoint you an attorney on this. If you don't want one, I'm not going to appoint you one. Okay? That costs the county money. I'm not going to do that. What you would have the right to do if you signed a waiver of right to counsel, you could change your mind at some other time and say, no, Judge, I don't want to sign that waiver of right to counsel. I want to hire a lawyer, or I want to request a court-appointed lawyer. But as long as that waiver's in there, I believe in you representing yourself, and I'm not going to appoint an attorney for you. But what that would give you is a chance that possibly you could work something out with Ms. Sessions. Maybe you could convince her that she doesn't have a case, and she should just sign a dismissal on this case. Maybe you could convince her if you signed a waiver of counsel, and she could work with you one-on-one with it without the court's intervention to see if she would dismiss the case. I don't know. She might give you some offer to dismiss the case. I don't know. But I don't know. That's all between you. You know, that's between the defendant and the prosecutor if you're representing yourself. Or if you have an attorney, it's between the attorney and the prosecutor to see if they want to work something out before we go to trial in the case. Understand?
Yes, ma'am. I hear what you're saying, but like I said, I do believe that there is some conflicts. I believe that the fairness on this, saying, okay, well, we're going to introduce all this felony stuff into your court as long as it comes from Ms. Session, is giving her kind of a pass that I'm not getting. And then you object and you tell me I can't say anything.
No, Mr. Damron, I'm granting your motion to strike her state's affidavit for good cause, and I'm not considering the state's affidavit for good cause for anything. So I've granted your motion to strike the state's affidavit for good cause. But at the same time, I'm dismissing your motion to dismiss because it was not filed timely before the information was filed in the case. All right? So I've done one of the two things you've asked me to. I'm striking the state affidavit for good cause because I don't find it's necessary, because I think it's unnecessary pleadings in the case, because I don't believe I have authority to hear your motion to dismiss because the information had already been filed prior to you filing it.
Well, the matters on this case, Your Honor, have already been asked and answered, and that's why I'm challenging the jurisdiction of this, because I don't think, just like you said, you don't have jurisdiction over the felony matters. This is a felony arrest that's been converted to a misdemeanor charge for the sake of convenience and time and strategy, maybe. But at the end of the day, Your Honor, I don't have any past. I don't have any drug convictions. And this, I have been.
That's something that's often worked out before a case is brought to trial.
And Your Honor,
those things are worked out between the prosecutor and the attorney representing the defendant, or the defendant representing himself. A lot of times those things are brought up, and the prosecutor is a reasonable prosecutor. I'm sure you're a reasonable man.
Yes,
and y'all
ma'am.
could probably figure out whether this makes reasonable sense to go forward with this case or not. But my options are limited because the information has been filed. My options to resolve the case are limited. My options are either y'all have worked out an agreement and I can approve an agreement. Maybe the agreement is to dismiss the case. Maybe the agreement is to work out some kind of pretrial agreement. Maybe the agreement is to work out a plea on the case. Maybe, no, y'all can't work anything out, and we just need to set it for a trial, a jury trial, and go to trial on it. And see, put the state on their burden. The state has the burden, Mr. Damron. It never switches to the defendant. You don't have the burden to prove the case. The state has the burden to prove the case. They will always have the burden to prove the case, and they've got to produce evidence beyond a reasonable doubt of your guilt before you can be found guilty of an offense. Do you understand that?
I do,
You have the
Your Honor.
right to remain silent. You have the right to not say anything that could be used against you. You have the right not to talk with the county attorney about your case. You have the right to have a lawyer. There can be a disadvantage to not having a lawyer, as you might not have advice from somebody that's been trained in the law to assist you with this legal matter. I have to tell you those things, okay?
I understand
I've
that.
told you those things.
I appreciate
all right?
that.
So now we're going to set the case for arraignment if you do not want to go forward with arraignment today. Arraignment is when the information is read out loud and you plead your plea of guilty or not guilty, okay?
Okay, we can do that. Would you want to set the what date did you want to set the arraignment for, Your Honor?
Set it on another date unless you want to go forward with arraignment today.
No, I would like to set it on another date, Your Honor.
Okay.
Actually, I need about 30 days, to be honest with you. This is not what and I'm sorry, I just didn't pack a lunch this big for this one, and that's just not,
Okay.
You guys do this every day, I don't. I'm just a pastor, is what I do. But, I just need a little extra time to prepare for this. I don't have the resources that you guys do.
Okay, what we're going to do is I'm going to get a date for arraignment, and I'll get that from the calendar in the other room. I'm going to go in there and step in there and do that. And then we're going to, is it okay if we email you a copy of the setting the arraignment?
I would like to get proper service, but, I'm going to...
You can get it by mail, or you can get it by email.
You can say both would be...
We don't serve it.
In the interest of time, and only because I also do the same, when I mail you guys, I also email Ms. Sessions and usually fax her too as well. So using the same common courtesy, I think that would be okay. I'm just not going to cure any errors in service from the beginning of this from up until now. I'm just not. I don't want to.
We'll give notice to your bondsman in
Thank you.
writing, and we'll give notice to the address that we have. Is the address that you provided on your pleadings correct?
Yes, on my pleadings, correct, yes. The P.O. Box, that is the correct address. You can send them
Okay,
there.
why don't you go ahead and give that to me again so we have it.
It's P.O. Box 424, Converse, Texas.
Converse.
Just like the tennis shoe. Yes, ma'am. 78109.
And your email address?
It's EMM. That's Edward Mary Mary Edward Tom Tom. So that's Emmett.Damron Damron @yahoo.com.
Okay, EMM. I got that far. And
ETT. ETT. So it's Emmett.Damron @yahoo.com.
So EMMETT.DAMRON@yahoo.com. Is that right?
Yes.
Okay. And your address is P.O. Box 424, Converse, Texas 78109.
That's correct.
Can I have a phone number that we can reach you on?
The 830-890-3955.
830-890-3955. All right. I am going to send you notice of the arraignment. I'm going to go get you the date and tell you verbally the notice of when you're coming back for arraignment. And
Alrighty
then
then.
I'm going to also send you a waiver of counsel, which you can sign or not sign. But I will send that to you, and you can provide that back to the court by mail it to the clerk's office, or providing it to my court coordinator who gave you the notice today, which is M. Lopez
Yes, ma'am.
at co.houston.tx.us.
Yes, ma'am.
If you do that, I will provide that to the county attorney, and she may contact you, and you could talk with her or not talk with her, as you so choose, if you sign the waiver of counsel. But without the waiver of counsel, she will not talk with you about working out an agreement, because we do not have in writing that you're waiving your right to counsel. But that's a waiver you can sign, and you can withdraw at any time. You can withdraw it as simply as you would be in a conversation with Ms. Session, saying, I don't want to talk to you anymore. I want to invoke my right to counsel. Okay? So that's a right that you have to invoke at any time. It's an important right. It's a right the Constitution gives you. It's a right that's important because it gives you somebody that can counsel you, that is advised, that is aware of what the laws are and they apply to your case. Okay?
I hear you, ma'am.
If you want to represent yourself, the waiver of counsel would assist you in the process of being able to represent yourself and talking to the prosecutor about possibly resolving the case. You understand that?
I do hear you, ma'am. Yes.
So I will send you the reset and the waiver of counsel. All right? And so we're resetting it for arraignment. You're here today. You've already been given notice of the case, so we're resetting it for arraignment. How about May the 3rd?
Okay.
Mr. Damron, when is and we can do that by Zoom, so you do not have to travel here.
Yeah.
What time is a good time for you? We're pretty open on May 3rd.
Let's do May 3rd is. Okay.
Okay.
Yeah, I'm pretty good. Let's do 9 o'clock. Does that work for you all?
That works just fine. And we will provide you the notice in writing, and we will provide notice to your bondsman. It's really your bondsman's responsibility to let you know when you have court as well. Okay?
Okay.
So,
I mean.
all right. That concludes the hearing today. I will note on the docket sheet that I am denying the motion to dismiss the motion to dismiss that was filed on January 28, 2021.
Are you gonna are you gonna be able to give me a reason why? Is that gonna be in your order, or should I request it?
I will put it in an order, and I will provide that to you as well. The basis is that the matter was mute after the filing of as it was filed after the information was filed. All right, that concludes the hearing today. Thank
All
you
right.
all.
Thank you, ma'am. Well, isn't that going to get interesting?